Welcome back to Court TV Live. I'm Ted Rollins. It's time for the Daily Sidebar. This morning, defense attorney Eric Nelson asked the court to allow his team to offer additional information about an arrest and subsequent hospitalization of George Floyd. That incident happened a year prior to his fatal encounter with Chauvin and his fellow responding officers. The incident in 2019 has some striking similarities to the incident at the center of the Chauvin's criminal case, namely the alleged presence of drugs in Floyd's system and in his car. Take a look at a clip from the body-worn camera of one of the officers who responded in 2019.
He won't listen to what I have to say.
Put your hands on top of your head.
What y'all doing on your head?
Top of your head.
Okay, man.
Open your mouth. Spit out what you got. Spit out what you got. I'm going to tase you. Spit it out.
I'm out.
He's eating
No,
all
you
night.
jerk away from me. No, I was one yellow pill.
Put your...
How y'all doing me like this, man?
What do you got there?
Man, what you got there?
Joe, you want to assist him? Just
I got my paper.
So what I'm asking you
I got
on
something.
camera,
Please,
she undo your
Come
zipper.
on, man. Please, man.
No, I didn't.
Why is it open then?
I don't know. God, man.
Okay.
Damn,
You got something
man.
down your pants?
Listen, man. Let's go. Y'all rough this up like this, man.
Dude, act like a man.
No, man, y'all wrong, man. I'm not even moving, man.
You got all kinds of pills on you.
I don't have no bill on me. I don't have no bill on me.
Pull them out of your pants.
There's one that just dropped right there.
All right, I want to bring in my colleagues, Julia Jade, who is on site in Minneapolis, Minnesota, Julie Grant, and Michael Ayala also with us. Julia, I'm going to start with you, but first, before we talk about this, which has been litigated now multiple times, this is very important for both sides, this issue of the 2019 encounter with police. Let's first listen to some of the defense argument this morning.
The entire arrest in May of 2019, just over a year prior to Mr. Floyd's death, is remarkably similar in multiple ways from one to the next, from the May 6th of 2019 to the May 25th of 2020 arrests. Beginning with literally the initial approach of officers and how the officers reacted to Mr. Floyd in that circumstance. In both of these cases, Mr. Floyd is in a vehicle. In one, it's a traffic stop, and the other, he's already parked. Officers approach, and the officers notice that Mr. Floyd begins acting furtively, hiding his hands. He's refusing to show his hands. Both officers, in both incidents, draw their weapons and I guess, escalate the use of authority or force in that regard. Mr. Floyd struggles, they struggle to get Mr. Floyd out of the car. Mr. Floyd immediately claims that he has previously been shot in both incidents. Mr. Floyd, again, struggles to get out of the car. He appears to resist their efforts to handcuff him. And he starts saying some of the exact same things that he says in this particular case, in the May 25th of 2020 incident, including calling out for his mama. He claims to have been shot, and he begins, this crying, kind of erratic behavior. All of Mr. Floyd's behaviors at that point are identical. Now, in the May 6th of 2019 incident, officers actually observe Mr. Floyd begin to put what they suspect are controlled substances in his mouth. And they threaten to tase him. They say, spit it out repeatedly. Mr. Floyd refuses to comply. And he obviously takes these controlled substances. A search of the vehicle in the May 6th of 2019 incident reveals a large quantity of a variety of controlled substances. At the time of the original motion in this case, we had taken screenshots from the arrest in May of 2020 showing what we believed to be controlled substances in the mouth of Mr. Floyd at that time.
All right, Julia Jade, this is one of those pretrial motions that both sides have a lot of fight because it is so important. Give us an just a sense of how much back and forth there's already been.
The defense has been trying to get this in since last year. Early in the case, it's been denied by the judge by order, and they are again bringing it up. This is the second or third time I've heard the defense bring up this May 2019 arrest. And what they want is to get this evidence in whatever way they can through the rules of evidence, because showing those similarities would neutralize some of the most sympathetic things about George Floyd's death and the video that everyone watched. If they can show those similarities and that he acted the same way, said the same things, was acting like he was being hurt in both of these incidents, they think that that'll take the sting out of some of the hard video that this jury is going to watch with George Floyd there being arrested and held on the ground by the defendants.
One of the things that Judge Cahill, Julie, was pushing the defense on is, what does it matter? They're saying, oh, he acted the same way. He was hysterical. He was saying some of the same. And Judge Cahill says, who cares what his emotional response was? Let's listen to some of that.
Why is his emotional response relevant to any of the elements in this case? The medical one I see, you're claiming that this could be due in part or maybe in whole, I don't know what the defense is, to opiate intoxication or other drugs intoxication could have caused his death. It seems to be very relevant on that, but as far as the emotional, as I said, his emotional response, one way or the other, why do we really care? It is what it is. It's not really something we have to have more evidence about regarding May 25th.
Well, Judge, I think it goes to, this goes to the very nature of this case. And why the public perception of this case is perhaps what it is. The things that he is saying, right? I can't breathe, I'm claustrophobic, calling out for his mama. These are things that his emotional state goes to, the juror. We've heard from dozens of jurors who have had a very negative response to that. It puts it into perspective of his common modus operandi is to have that same emotional response, first and foremost, but also above and beyond that, Your Honor, as the court we discussed yesterday in terms of Dr. Vincent's testimony, if these responses are attributed to panic disorder or PTSD or anxiety attacks, it certainly goes to counteract or contradict any claims that his emotional responses are indicative of something in response to his social upbringing or his panic, his PTSD. I certainly would see that it goes to that.
All right, Julie Grant, what's your take on this? Should this come in?
Yes, I think so, Ted. And I said it several months ago because we know, as Julia pointed out, this has been litigated and relitigated, as you both have said. And yes, my position hasn't changed. I think this should come in because it's so specific. And I think what Eric Nelson's trying to do there is sort of lay the groundwork for that hearsay to come in later, because George Floyd's statements would be hearsay, but they're offering them not for their truth, but for the effect they had on the listeners, being those police officers, the ones in 2019 and the ones in 2020. And if I may, Ted, I dug into the rules very carefully. And when you read the comments to the rules of evidence, a lot of times they shed a lot of light on what should be argued here. And I thought Eric Nelson did a fine job. He went through the list of how this evidence is not being offered to show action and conformity therewith, but it's offered to show another purpose. And before Judge Cahill, he listed nearly everything that the statute does: intent, common scheme or plan, absence of mistake. And while I think absence of mistake is spot on, I think he could also go a step further, and the comments to the rule make it clear that that is not an exhaustive list. So attorneys can come up with other grounds. They can say, look, Your Honor, this is not being offered to show bad character. This is being offered for another purpose. And here, Eric Nelson said it. The purpose is to show avoidance. He wants to show this court that there was arrest avoidance that was trying to go on. And he's going to try to make the argument that on the 2019 date, George Floyd was able to avoid going to jail and go to a hospital instead because of ingesting those pills. And then on the same date that's in question in this case, again, ingested pills, and we all know the result there. But I think that this is so specific and so nearly identical. I really think the judge is getting closer and closer to being convinced to let it in, Ted.
Michael Ayala, do you agree with Julie Grant? Should this video make its way in some form into this case?
I think one thing that has to be mentioned is there's a check on that 404B, and that is if its probative value or the prejudicial value outweighs its probative value. And I think that's certainly something that has to be considered by the judge here. Extremely prejudicial to let this in. But I have to say, Nelson's arguments this morning were convincing on one level. If we heard, as we heard yesterday, the state is going to bring in an expert to argue that some of what we saw there on the video of the arrest video from 2020 that involved Chauvin was not a response that was because of drugs, but because of his PTSD or consistent with someone who has anxiety or claustrophobia. Then if he wants to bring in, Nelson wants to bring in this evidence to show that this is a normal way in which he resists arrests, and they're going to argue in opposition to what the state's saying, I'm thinking there it may have some usage. And then he went on to say that, in fact, he also wants to use some of the conversation that the paramedics had with him after that arrest, that the amount of drugs in his system at that time, because he did ingest the pills, were going to have a certain type of effect on his body. That, too, is something that can be brought in. And the judge seemed to be receptive to that argument. So he has to weigh the prejudicial effect versus the probative value, but the arguments are getting closer, and I think he's getting closer to agreeing with the defense.
Yeah, and the fact they found the pills with Floyd's DNA in that
Yeah.
cruiser, and then, it sounds like the judge has said you can bring in that paramedic, and if they bring in the paramedic, he or she will testify that the heart rate was through the roof, and that he had expressed that he had ingested those drugs.
Ted, hold on. He did also say something that we've actually talked about amongst ourselves about, and that is this idea that you take your defendant, or you take your perp, or take George Floyd as you find him, right? You come to the scene as a police officer, you take him as you find him. And we also have to remember what they knew at the scene. So even though he may have acted that way, he is acting a certain way under that particular set of circumstances on May 25th, 2020, which they have to deal with regardless of what he did in 2019. So there is two ways to look at it.
Right, and the officers had no idea about the 2019 arrest. It's not as though they were like, oh, here's the guy that fakes his, does this or that. I want to talk about this other incident, and that is the bombshell $27 million civil lawsuit announced in the middle of jury selection on Friday. This has created quite the wave. The defense is very upset by it, and they have asked for a number of remedies. And thus far, Judge Cahill has denied a few of them, the extra strikes, but he's continuing to have it under advisement. He's going to bring in the 7 jurors that were seated. See, what do you know about this? I just want to gauge all of this. Julia, first of all, this is a huge part now of adding to this case, all of the complexities of this. Now we have this, and Judge Cahill is going to bring them back.
It's compounding things. It's another thing this court has to deal with that's not happening inside the courtroom. They already have to deal with the pretrial publicity in this case generally, and now another issue is before them. But there's going to be this unique approach to it where Judge Cahill is going to bring a number of those jurors who are already seated in via Zoom, and we'll ask them those questions. It won't be normal voir dire, won't be the attorneys asking questions, but the judge is just going to make that check that judges usually do to see if they've heard of anything. But I thought it was interesting today that one of the jurors said that he heard about the settlement, but he was not dismissed for cause. He had to be, the strike was used by the defense. So not just something that is for cause if they have heard about it, or that they'll be immediately dismissed if they are.
Yeah, he said he could put it behind him, and they had to take his word and use it as strike. Julie, how important is this, and potentially for this jury, if indeed some of these 7 jurors come back and say, yeah, I heard about it, what then?
Yeah, Ted, this is a massive problem for this criminal trial. It really and truly is, because at the heart of every criminal trial, the right that is most important is the right to a fair trial that every criminal defendant is guaranteed. And no matter what anybody thinks going into this process, we've seen several prospective jurors who have been appalled by what they saw on that videotape. no matter what the accusations are, that right has to be guaranteed. And because this has been let out, I think it's problematic for both sides. For the defense, of course, it's problematic because you're going to have prospective jurors saying, well, oh my gosh, if the city settled and they found, this conduct to be liable, they paid out all this money, then my goodness, he must be criminally liable too. And then I think for the prosecution, it can also be problematic because what if you have jurors who might say, well, that enormous amount of money was enough justice. I'm going to decide to do whatever I might do, maybe not follow the law or follow, who knows. But I think it can really cut both ways. This timing was terrible. And I think it's most terrible for the Chauvin team that's defending him. And so I think they're right to keep resurrecting this issue before the court. And Judge Cahill has a very weighty decision to make, Ted, about whether or not to continue this matter.
Yep, and he's keeping it under advisement. We're going to step aside, take a break. We will have more of the Daily Sidebar when we return. Stay with us.